Okay. Well, I just wanted to thank everybody for joining us for the Environmental Law Center's webinar. Today I just wanted to go over the recent changes that have happened to Canada's federal environmental assessment laws. And as well, I was going to provide an overview of a project finished pretty recently by the Environmental Law Center, which is our Model Environmental Assessment Law Project. Just to begin with, I just wanted to provide, for those of you who don't know about the Environmental Law Center, just a brief overview of what we do. Our mission is to ensure that Alberta's laws, policies, and legal processes sustain a healthy environment for future generations. We have several core services. We participate in law reform work. We provide information and education to the public, and we also provide support for those participating in Alberta's environmental law processes and procedures. We have 4 core priority areas that we work in: water challenges, land stewardship, environmental assessment, and projects dealing with promoting genuine interest standing. All right, so now let's get into the meat of the presentation. The first thing I wanted to go over was a review of the changes that have happened with the Federal Environmental Assessment Act. In 2012, the federal government introduced its budget bill, its omnibus budget bill, known as Bill C-38. And that bill made several changes to federal environmental laws. And one of the changes that it made was to repeal our Canadian Environmental Assessment Act and replace it with a new Canadian Environmental Assessment Act, which I will refer to as SIA 2012. And there's several significant differences between the old SIA and SIA 2012. And I've set them out on the slide here, and I'll just go through each of those points in greater detail. The first change that was made by SIA 2012 was to change the application of the Act, the way in which the Act will apply to projects. Under the previous SIA, we had what was referred to as a trigger process. So projects were tied to some sort of government action. It could be federal funding of a project, federal land was involved. It could be a case where the federal government was actually a proponent of the project, or there was a particular decision being made by the federal government. And those decisions were contained within an act, regulation to the Act known as the law list. And it included things such as issuance of a Fisheries Act approval. As well, the old SIA could apply if there was transboundary impacts. Under the new SIA, under SIA 2012, we no longer have triggers. What we have is a project list. So only projects that appear on a designated activities regulations list will be subject to federal environmental assessment. That list doesn't include generally federal projects where the federal government is the proponent. The project list under SIA 2012 is essentially the comprehensive study list that was developed under the previous SIA. And those were a subset of all the federal environmental assessments that would be done. And they were those projects that were known to have significant environmental impact and to be quite controversial. It didn't mean that if you weren't on the comprehensive study list, a federal environmental assessment wasn't warranted. It was just identifying those projects for which a high level of assessment was always necessary. So that list, essentially the comprehensive study list, has been taken and moved into SIA 2012 as our new project list. So the end result of that is that rather than having thousands of federal environmental assessments done annually, we will probably have, I've heard numbers as low as 30, as high as about 50. So a very significant reduction of the number of assessments done on an annual basis. The other thing that has changed between the previous SIA and SIA 2012 is who will be responsible for conducting the assessments. Under the previous SIA, we had a self-assessment model of environmental assessment. So any federal government agency or body that was going to be making a decision would be responsible for conducting the environmental assessment leading up to that decision. The new SIA 2012 moves away somewhat from the self-assessment model, and there are only right now 3 authorities that would be conducting environmental assessments federally. There would be the NEB, the National Energy Board, and the Canadian Nuclear Safety Commission, and there's also the Canadian Environmental Assessment Agency. The vast majority of federal environmental assessments will be conducted by the Canadian Environmental Assessment Agency. There are certain projects on the list that are tied to the National Energy Board or the Canadian Nuclear Safety Commission. Those projects are assessed by those agencies. There are provisions too within SIA 2012, sections 67 to 72 of the Act, that deal with impacts on federal lands. If a federal authority is dealing with a project that might impact on federal lands, they are required to do an assessment. However, it is not an assessment that necessarily requires public involvement, and the assessment, how it's going to be conducted, is entirely up to that federal authority. So, for instance, Parks Canada is responsible for setting out its own assessment process for impacts on federal lands, i.e. the national parks. So that's a really very pure form of self-assessment. There's not a lot of public involvement, and it's really up to the authority itself to determine how it's going to assess impacts on federal lands. So basically, we've got a contraction of the number of parties doing assessments. At the Environmental Law Centre, we have recommended that assessments be put into the control of one central party, like the Canadian Environmental Assessment Agency, because we think that would promote consistency and efficiency, but we would like to see all assessments being done by that one central agency. Another impact that has happened with the introduction of SIA 2012 is a reduced scope of assessment. Under the previous SIA, the definition of environmental effects was quite broad. It included land, water, air, organic, inorganic matter, all living organisms, and the interacting natural systems. However, under SIA 2012, the definition of environmental effects has been greatly reduced. It's now limited to federal lands, impacts on Aboriginal peoples, fish and fish habitat, aquatic species at risk, migratory birds, and changes that are linked or incidental to a federal authority's exercise of power. So the scope of assessments is greatly reduced. The SIA 2012 takes a very restricted view of what federal authority to act in the environmental arena is. And it's really contrary to a lot of case law, which takes a much more expansive view of federal authority. As well as reducing the definition of what an environmental effect is, the content of assessments has also been changed. They're, by and large, very similar between the previous SIA and SIA 2012. If you're interested, Section 19 is the section that lists all the items that must be considered within an environmental assessment. But there are a couple of significant differences between the list in SIA 2012 and the previous SIA. In SIA 2012, there is no longer a requirement to consider the need for the project, nor is there a requirement to consider alternatives to the project. Both of those factors are generally considered to be really important items to look at in the course of an environmental assessment. Another aspect that has changed between the previous SIA and SIA 2012 is public participation. There is a potential that public participation will be limited under SIA 2012. In some cases, SIA 2012 says that participation is limited only to interested parties. And interested parties are defined as those people who are either directly affected by the project or have some sort of relevant information or expertise to the project. So there is a potential that that could be interpreted quite restrictively, and therefore there'd be less public participation. I think we're going to have to wait for time to tell us how review panels, how the agency are going to interpret that provision, but the potential exists for reduced public participation. As well, the manner in which SIA 2012 and the previous SIA deal with jurisdictional overlap has changed. Jurisdictional overlap often happens in environmental assessments because both provincial and federal governments have authority in environmental issues. And so it's not unusual for a project to be subject to both federal and provincial environmental assessment. So the question then becomes, well, how do you coordinate that? How do you deal with the fact that there could be two environmental assessments? Under the previous SIA, the idea was that there would be cooperation and coordination between the federal governments and the provincial governments, and that both processes would still proceed, but they would proceed in a coordinated and cooperative manner. Under SIA 2012, that is no longer going to be the approach that's taken. The SIA 2012 has introduced the concept of substitution and equivalency. With a substitution, the federal government would still be making its decision. However, it would not be conducting its own environmental assessment. The provincial government would use its process, and then the federal government would use the information from that process to make its decision. In the case of equivalency, what will happen is the provincial process will be deemed equivalent to the federal process. The federal government then will entirely step out of conducting an environmental assessment, and the only assessment happening will be the provincial assessment, and effectively SIA 2012 will be deemed not to apply because the provincial process is deemed equivalent. We at the Environmental Law Center are concerned. We think that's not a good trend. It is the federal government stepping out of conducting environmental assessments, and there's a potential that could happen even in areas where there's a clear federal authority to act, such as impacts on fisheries. The other concern with this approach is that there is really a patchwork across the country. Some provinces have very different standards of and different processes, and so we're going to have situations where similar projects could potentially be treated quite differently depending on which province they are occurring in. And finally, another difference between the previous SIA and SIA 2012 is the imposition of statutory timelines. Under the previous SIA, there were some timelines introduced by regulations requiring that comprehensive studies be finished within a certain amount of time. With SIA 2012, we have now the imposition of statutory timelines. They're actually within the legislation. They're not within a regulation. And a standard environmental assessment must be completed within 365 days. A panel assessment must be done within 24 months, and a National Energy Board assessment must be done within 18 months. There's concerns with having these restrictive timelines in place. There will be situations where you just have a complex project with complex issues, and more time is just necessary. It's just the nature of the project that's being considered. So the concern is there will be less complete environmental assessments being done in order to meet these rather arbitrary timelines that have been imposed by the legislation. So, what do all these changes to the Environmental Assessment Act? Well, we're going to end up with a Federal Environmental Assessment Act that has fewer assessments, going from thousands. Oh, I see somebody's hand. Sorry, I see a raised hand here, and I'm wondering if I should look at that. Maybe there's. Can you repeat the difference between equivalency and substitution? Yes, I will do so. The difference between a substitution and equivalency is the level of federal government involvement. With a substitution, the federal government will still be looking at environmental assessment information and making its own decision. So it will take the information that's gathered in the course of a provincial environmental assessment. It will look at it, consider it, and then make its own call on whether or not the environmental impacts are acceptable. Whereas with an equivalency, the provincial process will be deemed equivalent to the federal process, and the federal government will essentially say that because the provincial process is equivalent, we no longer need to do an environmental assessment, and SIA will not apply in this case. So they're not even making a decision on the environmental assessment information. All right. Sorry, I kind of get distracted sometimes by the questions popping up. Okay, so that I have a note that that was more clear. Sorry about that. That wasn't clear in the first place. It is a fairly new, it is a new mechanism, this equivalency and substitution, and so I think, again, in practice, we're going to find out more and more how that works. There have been recent agreements between BC and the federal government deeming the BC process to be an appropriate substitution for some projects. So that means the federal government won't be conducting its own separate environmental assessment. They are instead going to be relying on whatever BC comes up with. So it's starting to be used, but it, again, is a very new mechanism, and we're going to have to just wait and see how it all pans out, I think. So just back, a brief overview of what all of the changes between SIA, the previous SIA and SIA 2012 mean. We're going to have fewer assessments. We're going from having thousands per year down to probably 30 to 50, somewhere in that range. The assessments that are going to be done are going to be done with a reduced scope. They take it a very restricted view of what the federal government's role is, and they're sticking to that. There's concerns there's going to be reduced public participation in assessments, and that there may be a reduction in the amount and the quality of information collected because there's now going to be statutory timelines that need to be met. I'm wondering, my next part of the presentation is moving on to the Environmental Law Center's Model Environmental Assessment Laws project. I do see there's a couple of questions. Do you want me to answer those questions first? Would that be preferable before I start moving into the model laws, because it's a bit of a switch? I don't know if anybody wants to just say yes, or if you just want me to hold it till the end. Actually, I see only one more question. Yeah, okay, Leah. Okay, thanks, Leah. There's the one question, is federal environmental assessment required for a project on the project list, even though no federal government trigger of any kind would be required for the project? That's a good question, because that has been raised there, especially with respect to pipelines. I think it's 75 kilometers. There is a potential that you could have a pipeline of 75 kilometers that's completely within one province and doesn't cross water bodies or anything. So previously, that would not have triggered an environmental assessment federally because there would be no federal trigger, right? There wouldn't have been impacts on fisheries or water. There wouldn't have been a transboundary crossing of the pipeline. And so it would have just gone provincially. But now with the new list, that would it would trigger the application of SIA 2012. What happens though with SIA 2012 is unless your project is directly tied to the National Energy Board or to the Canadian Nuclear Safety Commission, it goes to the agency, the Canadian Environmental Assessment Agency. And then the Canadian Environmental Assessment Agency looks at your project description and determines whether or not an assessment is actually required to happen. So there is a potential that while your project fits on the project list, you would submit your description to the Canadian Environmental Assessment Agency, and then they look at that to see if there's environmental effects as defined in the Act. So they could look at that and find, well, there are no federal triggers, and so we're not going to do an environmental assessment. And I think that's probably how those projects, which maybe are a bit borderline, there might have not been previously a trigger for them, but now they're on the project list. The assessment is what's going to happen is they're going to have to submit a project description, and then the agency will look at it and probably find there are no triggers, and so we're not going to do an environmental assessment. Does that clarify that? Just wait to see. I think that was Kirk who had asked that question. And also just to a bit further on that, I think that's probably part of why the federal government has introduced proposed amendments to the project list. It was about 2 months ago, month and a half ago, the federal government introduced proposed amendments to the project list, and they've added some things on and they're taking some things off. So they, I think, realized there was a few issues, and they're trying to address those. Is the project Jeff? Yes. So you could have a project that's now on the list and doesn't have any of our kind of prior triggers that SIA would apply to. Whether or not an environmental assessment actually comes out of that is a different question, because the agency could determine an environmental assessment is not necessary. So I hope, is that clear, Kirk? Okay, thanks. So I think that was it for that I see questions on the changes to SIA. I think that was it for this part of the section. Oh, will we ever see another panel review? I don't know. They're under SIA 2012, you can have panel reviews. Oh, sorry, I think somebody's trying to get through on my phone here. All right, I'm going to now move on to the next part. Oh, can we come back to the panel review? Jamie, all I can really say in response to that is under SIA 2012, you can have panel reviews. I guess whether or not one will ever happen again is maybe a different question. All right, so now on to the Environmental Law Center's Model Environmental Assessment Laws project. This is a project that was funded in mid-2011 by the Alberta Law Foundation and Alberta Eco Trust. And the project was originally developed in anticipation of the 2011 SIA statutory review process. And under the old SIA, there was a requirement I think the most recent requirement was that every 7 years a review had to be held of the Act to make sure it was functioning if it needed to be updated. And so there had been a previous review of SIA, and that happened in 1999, and expectations were that the process in 2011 would be similar to the 1999 process, which was very extensive and thorough. However, that was not the case. The review process for SIA most recently commenced in late 2011, which was a year later than it ought to have occurred, and it happened in a matter of weeks rather than months. And the review was abruptly ended on about 2 days business notice. Everyone was told to get their comments in, and witnesses that had been scheduled were just canceled. And then, as we all know, in 2012, the federal budget bill was introduced, and federal environmental assessment laws were entirely rewritten. As part of our model law project, the Environmental Law Center did provide comments in the statutory review process. We also participated in consultation that was held in relation to the new SIA and its regulations. And at the same time, we continued to work on developing model laws. The object of this project was to develop a federal and provincial model law which addressed concerns with current environmental assessment legislation. Ultimately, the idea was to design a model law that could provide a foundation for sustainable decision-making. The model law embraces the idea of sustainability and asks the question of whether an undertaking will make a positive contribution to sustainability, looking at environmental, social, and economic components and the interaction of those components. So it's a contrast with our current environmental assessment process or approach, which tends to focus more on what are the negative environmental impacts and how can they be mitigated, rather than trying to select projects and undertakings that are going to contribute in a positive way to sustainability. Ultimately, our goal is that the government will look to the model laws to improve existing environmental assessment processes. The model is set up with near federal and provincial laws. There are some differences between the federal and the provincial version, and those are highlighted in the model law document. When I speak about the model law today, I'm going to focus on the federal version, just because we've just been talking about federal environmental assessment law. But again, they're mere legislation, so they're by and large are the same, but there's some slight differences. So I'm just going to provide a highlight of some points of our environmental and environmental model law. We've actually come up and we've called it a model environmental and sustainability assessment law, rather just an environmental assessment law. As mentioned, the core objective is to help Canada achieve sustainability. And sustainability is defined as planning that acknowledges the inherent limitations of the environment, that is socially, culturally, economically, and environmentally sound, and that meets the needs of the present generation without compromising the ability of future generations to meet their own needs. And the model law considers whether or not an undertaking will make a positive contribution to sustainability. And as I mentioned, that's different than CF, which looks at whether or not a project causes significant adverse environmental effects and whether such effects can be justified in the circumstances, which leads to people looking at a project and saying, well, what are the bad things that can happen and what can we do to either stop it or make them a little bit less bad, rather than trying to choose and create projects that will make a positive contribution to sustainability. So the model law sets out several factors that need to be considered in the course of an environmental and sustainability assessment. I've listed a few here. There's other factors that need to be considered, but unlike our CIA 2012, the model law requires that the purpose and the need for the undertaking be considered, as well as potential alternatives to the undertaking. And one of the alternatives to an undertaking is the no-go alternative, right? What would happen if we don't proceed with the undertaking? And overall, the idea behind the factors listed in the model law are to focus attention onto the choice and design of undertakings that will make positive contributions to sustainability. And again, to move the focus away somewhat from just looking at how to minimize and mitigate negative impacts, but also how to enhance and create positive impacts. So, just as with our current CS 2012, the model law requires environmental and sustainability assessment of project-based undertakings. And in the federal model, there are several different triggers. So it goes back to a trigger approach rather than having a project list. And the triggers are where the federal government is a proponent, where there's federal lands involved, where there's federal funding, or a federal decision. It also requires or sets up as a trigger matters of national concern. And those are listed in the Act and include transboundary impacts, impacts on multilateral agreements or treaties that have an environmental or sustainability component to them, impacts on species at risk, threatened or endangered ecological communities, any impacts on migratory or transboundary species, projects that would have a significant contribution to climate change, or impacts on fisheries, marine areas, or navigable waters. As well, there is, under the model law, a possibility of establishing a list. And that list could be formed in a few ways, in a combination of ways. You could provide a list similar to what we currently have, which is lists of projects. But you could also provide a list of environmental impacts. For example, a project that's going to, contribute X tons of greenhouse gases to Canada's climate would have to be looked at. So it's not just, the list doesn't have to just contain project descriptions. It could also include descriptions of impacts that we want to look at as a matter of concern federally. The next type of environmental and sustainability assessment that is required by the model law is strategic environmental assessment. And this is not currently required by our SIA 2012. We don't have within SIA 2012 anything set out for strategic environmental assessment. Although there are some references to doing regional assessments, they're not a requirement. There is a cabinet directive which does say that government policies should be subject to environmental assessment. However, it's not very transparent, and it's a cabinet directive. It's not a legislative requirement for strategic assessment. So this is one of the gaps in our current legislation that the model law is suggesting should be filled. And the model law sets out 3 different categories of strategic environmental and sustainability assessment. One is assessment of proposed policy plans and programs. The other is assessment on a regional basis. And thirdly, a strategic assessment is the development of a code of practice. And the idea behind this is to do a strategic assessment, develop a code of practice that can deal with the smaller routine projects, which perhaps individually might not have a huge impact, but when you look at the cumulative impacts of them, can have a fairly large environmental footprint. And so the idea is to attempt to develop a code of practice that would be quite restricted, would only apply to a very specific type of project in a specific location, and so forth. And once that code of practice is in place, if you fit within the code of practice, an individual environmental assessment would not be required. And the whole idea behind having strategic environmental assessment is so that you would have well thought out assessment of your policies, your plans, your programs. You could have a regional assessment that would provide guidance to future projects, and to have a place where broad issues that impact on many projects could be discussed, could be assessed, and dealt with. So, for example, you could have a national energy policy which could address the overarching issues, such as climate change, how should certain resources be developed, so forth. And that policy then has undergone an environmental sustainability assessment and would be used to guide future development. And so you would hopefully move away from having an individual project assessment where these issues, such as climate change, are being raised and perhaps aren't dealt with very well within the context of a project because they're broad issues and they need to be discussed at a broader level than just one-off project level. And we have had some regional environmental assessments done in Canada, for example, in the Beaufort Sea. So there is precedence for that happening in Canada. All right, on to the next slide. The model law does set out a list of triggers when a strategic environmental and sustainability assessment would be required. one instance would be if the federal government was proposing a plan, project, or policy, not a project, a plan, policy, or program that had a potential for sustainability impact. Another trigger for strategic assessment would be if another government was proposing a joint plan, policy, or program, or a regional environmental and strategic assessment. You could have a non-governmental body also proposing a government plan, project, or program, proposing a code of practice, or looking for a regional environmental and sustainability assessment. The other trigger or way in which the need for a strategic environmental assessment could be identified is if in the course of conducting a project-based environmental and sustainability assessment, it became apparent that there was a gap and there would be a benefit to conducting a strategic environmental and sustainability assessment. And then finally, the last mechanism for triggering strategic assessment would be through public petitions. All right. So I see there's quite a bit of discussion here on this side. I haven't been able to read it all about the sustainability model. So I'm just going to quickly finish up here, I think, so that we can have a bit of time to discuss this. This slide is dealing with the process that's set out in the model law, and it's a 5-step process. And the first step is a screening process. And this is a step to determine whether or not an environmental and sustainability assessment is required. If a project fits within a code of practice, then an assessment would not be required. But it would have to demonstrate that it actually fits within the code of practice. If the project demonstrates no potential for anything other than insignificant impact, then there would be no assessment required. But if there's anything indicating that there would be more than insignificant negative impact, then an assessment must be conducted. The next step in the process is the initial assessment. And the purpose of this step is to provide a process for scoping, including a review of the purposes and identification of appropriate alternatives to the undertaking to be examined. It would be used to set scientific standards and methodologies. It would be used to establish terms of reference and to determine what the appropriate type of assessment would be. The next step is actual review of the environmental and sustainability assessment. The environmental and sustainability assessment would be prepared by the proponent, and then it could be reviewed by an agency, the Canadian Environmental Assessment Agency, by a review panel, or by a joint review panel. The next stage is decision-making. The decision would be made by either the panel or by the agency. A certificate would be issued, and that certificate would include conditions on design, mitigation, and enhancement requirements. There would also be monitoring and follow-up requirements put into place in the certificate, and that certificate would have conditions which were enforceable. And finally, the last step would be for follow-up and monitoring. And this is where a lot of environmental assessment legislation kind of falls down. In the course of an environmental assessment, we make a lot of predictions, a lot of assumptions as to what's going to happen, and we don't necessarily follow up and find out if those assumptions and predictions are correct. And so it's an important element of environmental assessment that we follow up and monitor what we've predicted, what's actually happening, so that we can learn and improve environmental assessment into the future. And follow-up and monitoring would be required for all environmental assessments. All right, just a few other provisions I'm going to mention. Part 5 of the model law sets out the provisions for public participation. It is a requirement that there be meaningful and effective public participation throughout the entire environmental assessment process. That's what meaningful and effective public participation is defined in the Act, in the model law. There's also provisions for funding of public participation and for public assistance through education and guidance programs. There are provisions within the Act for petitioning for the environmental and sustainability assessment to be conducted. And then there are provisions setting up a registry to enhance transparency and access to information. There are also in Part 6 of the Act provisions setting out how the issue of multi-jurisdictional assessments is to be dealt with. We've espoused a cooperation and coordination approach rather than the substitution equivalency approach that's been adopted in SIA 2012. We also have set out in Part 7 a central environmental and sustainability assessment agency that would be responsible for the conduct and decision-making in environmental assessments. And Part 9 sets out offenses and penalties. As mentioned, the conditions set out in a certificate of environmental sustainability assessment would be enforceable conditions. They have to be abided by, or else you'd be subject to penalty. As well, if you require a certificate, you must get the certificate, or otherwise that would be an offense as well. All right, so for those who are interested, our model environmental and sustainability assessment law can be obtained online. I've put the link right here on the slide. There are two versions available. There's an annotated version which provides background information and discussion to the model law, and then there's a version available without the annotations. It probably makes more sense if you're going to look at one to look at the annotated version, just because you kind of have the background and the discussion as to why the model law says what it says. All right, I'll just put up this slide. If you need to get a hold of me, my contact information is there, as well as our Twitter account, our Facebook blog. All that information is available here on this slide. I'm going to look at these questions because I do see there's a bit of a discussion about using a sustainability model. I'll read out the questions. I assume you probably all can see them, but in case you can't, I'm going to read them out. So we have a question from Jeremy. Is the sustainability model realistic, considering so much of the country's development relies on natural resource extraction, non-renewable resources? And Jamie Mean responded, isn't that exactly why it's needed? Jeremy says, if we didn't have natural resource development, we wouldn't have much of an economy, not very realistic. And I'm sorry, I'm probably going to mispronounce your name. But FRIA, sustainability modeling is more comprehensive planning that integrates the development within more extensive consideration of the economic, political, social landscape. There's literature on it. I mean a strategic assessment literature. And Chris, okay, you're asking a different, okay. Sustainable, okay. So Chris's question, I think, is a bit different. So the question is the sustainability model realistic? Well, I think sustainability sometimes has snuck into our previous SIA anyway, because the central question in SIA is, one, is there a significant negative environmental impact? And two, is that impact justifiable in the circumstances? And to me, I've always thought that justifiable in the circumstances means, well, we've got negative impacts, why would we tolerate them? Are there social, are there economic benefits that make those negative impacts tolerable. And so the sustainability assessment sometimes sneaks in that way anyway, and there have been a few panel reviews where they've actually looked at sustainability factors. And it's not that a project has to be sustainable, it's that it's making a positive contribution to sustainability. Because you're right, I guess if you're taking non-renewable resources and pulling them out of the ground and using them, then you're kind of taking resources from future generations, and so arguably it wouldn't be sustainable. The idea behind the sustainability assessment is to have a more comprehensive look at what you're doing, looking at all the factors, looking at environment, looking at economics, social, cultural. How can we have the most positive contribution to sustainability possible? Should we maybe perhaps not take the resources out of the ground as quickly as we could so that we improve the economics of it? We can maybe mitigate and lessen the negative environmental impacts and enhance the social and cultural benefits. So it creates a more comprehensive look. That's the idea behind having a sustainability assessment. Okay, sorry, I'm just reading through the questions here. Says Jeremy F., what you said made sense. I was wondering if you could better define sustainable. Well, this is the definition that I've used in the model law. I'll just go back to that slide. What the model law has adopted as its definition of sustainability is planning that acknowledges the inherent limitations of the environment, is socially, culturally, environmentally, and economically sound, and meets the needs of the present generation without compromising the ability of future generations to meet their own needs. So that's the approach, that's the definition in the model law of sustainability. All right. Okay. Sorry, I'm just trying to, there's a couple here. Chris has asked, besides the tactical prosperity mine case, do you have any other examples of benefits of having cooperative federal and provincial processes both happening rather than the equivalency approach? I thought there was something else. Chris, do you mean the harmonized approach? There have been many harmonized approaches. That's what Jamie's response was. And then Jamie also said, prosperity represented a failure of harmonization, though the results were favorable in our view. And then Jamie has put up from West Coast Environmental Law a link to lessons from the Prosperity Mine environmental assessment. Okay. So just a brief review of what prosperity was. So prosperity mine is a mine proposed in BC, which was approved by the BC government and ultimately, though, rejected by the federal government because there were concerns with the destruction of a lake called, I believe it's called Fish Lake. And that lake had obviously fish in it, so it was fish habitat. The federal government was opposed to the project because of the damage to fish habitat. There was also cultural significance of the lake to Aboriginal groups. And so there was the federal government saying no to the lake, and the provincial government, or not to the lake, to the mine, and the provincial government had allowed the mine to go ahead. So ultimately the mine could not proceed because they didn't have federal approval. So that was where there was a cooperative federal and provincial process. There was two processes happening at the same time, and it ended up that the federal and the provincial government each had a different decision. So you're asking if there's other benefits. Well, there have been other cases where there's been joint panel reviews. I'm just trying to think. I can't think of any others off the top of my head, but we've had many, many cases where there's been joint cooperative federal and provincial processes happening. I think the concern with equivalency and substitution is that you're going to lose that federal perspective. You're no longer going to have both the federal government and the provincial government looking at a project. It's going to be just the provincial government. And as we saw with Prosperity, the provincial government said yes to the project, and it was the federal government who looked at issues that the province doesn't necessarily look at, like fisheries impacts, and determined that the project was not appropriate given the impacts on fisheries. So I think that's where the concern with having substitution equivalency comes from, is that that federal perspective is going to be lost. The federal government looks at things like fish habitat, effects on migratory birds. They look at transboundary impacts. They've got a different perspective than a province might have with respect to a particular project. All right. Did that answer your question, Chris? And I guess also Jeremy had questions about the sustainability. I see it's 1 o'clock too, so we have to, we're going to have to wind it up here. So I don't know if there's any other questions. You could send them to Leah and I can answer them later. Or if you need follow-up, if I didn't answer your questions that you did have. That's true. The question or the comment from Chris is he doesn't think the federal input would be lost as they could participate in the review. I suppose that is correct. However, they would not be a decision maker if there's an equivalency declaration. And I don't know how much they would participate if they decided that FIA doesn't even apply. So it's concerning to have equivalency and substitution. Federal input would not be the same as if they're doing their own assessment. All right. Okay, I think I had better, oh, sorry, Jamie's going on. Jamie has just commented, it's also a question of the scope of assessment as well as public participation requirements. And that is correct too, Jamie. I agree with you on that. As well, if you look at Arlene Kwasniak's paper, too, she does speak about even a province may look at water issues and the federal government may look at water issues. They're coming from a different perspective. They've got different roles to play with respect to water. You know, so that changes what they bring to the table and what types of decisions and what type of information is being considered when you have the federal and the provincial governments involved. All right, I think I'm going to just draw this to a close now. Thank you very much for your time. Yeah, you can, Leah's just put up her email address. You can just give her send her an email if you have any other questions. And thank you all for your time. I very much appreciate it.